short word of explanation. Usually I have a chance to go through these the morning before class. I've had a family urgency in the last 2 days, so I have not. And I'm also tired. That's not an apology, it's just if I stumble a little bit more than usual, there's a reason. And I hope some of this will show up in terms of the films that I think I have integrated into this. But I'll go through it stepwise, and feel free to ask questions because this is fairly new territory for me as well. In fact, Dawn and I have been carrying on an email conversation. And if there's any reason to be optimistic about challenging the powers that be, I think the application of common law based on Anglo-Saxon common law that's a millennium old or more, there might be a chance. So, I'm going to guess that you never asked yourself how a nation state, or city, county for that matter, do business. And I know for a certainty that I never did. By historical tradition, going back centuries, they actually established companies, in more recent times corporations, often by the same name as the city, county, or nation state, to do business with other business entities, whether you're having the trash collected, whether you are collecting taxes, whether you are establishing a military. You need business-to-business contacts. So that when we elect, for example, a president, we think of him as the President of the United States. But under the vast majority of circumstances, he actually and also is the President of the corporation known as the United States of America, in this case incorporated. The company that is doing business representing the sovereign of Great Britain, the King, or at the present time Queen Elizabeth II, is known as the Crown. It's a term that designates the investment company that is doing business for and in the name of the Queen. So whenever you talk about a nation state or a city or a government of any sort, there is a business entity, usually by the same name, contracting with other businesses to provide the services that that government needs. In fact, I virtually guarantee you that there is a business firm known as the War Department or the Peace Department or the Defense Department that is doing business in the name of the United States of America Incorporated. It's important to talk about sources when we're talking about governmental organization, because I will tell you there's a lot, an incredible amount of bullcrap on the internet, and I presume in history books about it. I am reminded of the little boy who found a barn in a barnyard and was scurrying around looking furiously for something, and his father asked him why, and he says, "With all the shit in here, there must be a pony somewhere." Well, the ponies that I have found are two sources, johnhenryhall.wordpress.com and Anna Maria Reitzinger. She's written 3 books, and her web is at www.annavadreitz.com. There are a lot of other sources, and they may be valuable, but I will tell you that it's absolutely astonishing the amount of nonsense and what I will call little green men kinds of information when you're talking about governmental organization. I don't know why. John Henry Hall either is or was a retired physician whose homes were, he left the United States, and based on what he has written at his website, I understand why, and was living, had a home in Crimea and had a home in Switzerland. And he has not made any additions to his blog for the last 11 months, so he may have left this mortal coil. But when he was writing, everything he has written I have found to be reliable and I've traced it down, you know. You take a reference, you cross-check the reference, you cross-check that reference, and John Henry Hall has proved to be reliable. That is mostly, maybe 99% true for Anna von Breitz as well. But she has written a whole lot more, and some of it is like pieces of a puzzle that she says fit in the puzzle, and I've not yet seen the edges of the pieces that coincide to the pieces that she's given me. But both of them are very useful writers. Both discuss the same reality with substantially different styles, and frankly, untying the Gordian knot, I'm still in the process of doing it, but I've untied it enough to be optimistic about the probable effective ways of challenging the mess and the corruption that is literally destroying our nation and has totally overwhelmed what we think of as our government. The legal and subsequently fraudulent evolution of the United States citizenship and the living man-woman in his or her relationship to the land. These are legal terms that, unless you understand them, Jello looks like pudding, looks like tapioca. You're talking about three different entities and they all have the same name. It's infuriating. Von Breitz starts her discussion with a medieval trust, a discussion of a medieval trust that theoretically was predicated on Pope Boniface's the Eighth's decree of Unum Sanctum, wherein he claimed to be the logical and real successor of Adam through Christ, through the Roman Catholic Church, to the papacy. And this claim is represented by three trustees of the Global Estate Trust. The papacy asserting jurisdiction over the air, the monarch of England exercising jurisdiction and authority over the sea, which turns out to be all commerce, by the way. When we're talking about commerce, in ancient days, commerce was conducted by ocean travel. If a tradesman sold you a good on the streets in London, England, he was a tradesman and he was a craftsman and he was participating in trade. But as soon as you went over an international border, you were engaged in commerce, which is why the leading power of the sea at that time took jurisdiction of the sea. And the jurisdiction of the land was exercised by the monarch of Spain at the time this theoretical trust came into existence. I've not yet, I believe von Breitz, but I have not yet been able to confirm that by alternative sources. What is clear is the conclusion that at the Revolutionary War, the jurisdiction of the land, at the conclusion of the Revolutionary War, the jurisdiction of the land, which is governed, this gets necessarily complicated, the jurisdiction of the land is governed by common law, the Anglo-Saxon tradition of the common law, which includes a magistrate that does not make any decisions. He's just basically, the magistrate in common law is a hall monitor. He tells this authority to go in that direction and this authority to go in that direction. And the common law, everyone knows the common law. Whether the common law is don't kill your neighbor, don't steal from your neighbor, whether the common law is to love your neighbor as yourself. The common law in England was do whatever you want as long as it doesn't damage, hurt another human being. And that other human being is free to go about his business, and you are free to go about your business. So common law is incredibly simple. I might make the editorial comment that lawyers, barristers are trained to win conflicts for their clients. In common law is set up precisely, going back all the way to the Magna Carta, is set up to protect the otherwise weak from the physical power of the strong. There are some very simple rules to common law. In common law, a statement that goes unchallenged becomes fact in law. If it's unchallenged, so if I say something about Catherine and she keeps her mouth shut, in terms of the fact of law, that becomes recognized as true by the jury of 12 people. So, and there are a half a dozen other similar principles, okay? But the jury of 12 is not the jury of experts. It's a jury of common people who know, by and large, what's fair. They don't need 3 years of training at Harvard Law School to know what is right if Catherine kicks Janet in the shin. Now, one of the unfortunate things about common law is that the penalties are relatively severe. For example, though I don't know this to be a fact, there are relatively few physical penalties in common law, and the most obvious one is the death of the perpetrator. So let's suppose you steal somebody's cow and you don't have a cow to pay him back with, guess what? So common law can be severe in terms of its penalties, but in terms of the 12 jurors deciding what is fair, 12 people off the street, by and large, unless they have been, and this goes to the 20th and 21st century, it is an unfortunate fact, and it's unfortunate even with respect to common law, that people can be sold a bad bill of goods by intense selling. But that's not allowed in the court, but that's assuming that your jurors come into the courtroom unbiased. But all of that is secondary to the assertion that the jurisdiction of the land is governed by common law, and that common law jurisdiction fell to the government that was established by the Articles of Confederation, fell to the United States of America. And you'll notice that I did not capitalize United, because the correct title of the governmental agency that was established in 1774, I'm open to challenge on this. We know that the Declaration of Independence was developed and signed at 1776, but I believe the Articles of Confederation were collected and signed a year or two before that. If I'm wrong by a year, forgive me. The jurisdiction of the sea at the end of the war for independence was yielded to the crown. That is the company doing business for the king. Why? Why did the United States company yield jurisdiction of the sea to a foreign power? For a number of reasons. Remember, the jurisdiction of the sea refers to international business, not national business. Because a person selling a piece of goods in London is participating in trade. That same person selling the same good to an American is participating in commerce. And it is the jurisdiction concerning commerce that is the jurisdiction of the sea. Now, Britain had the world's best navy in 1783, and the United States had no navy whatsoever to speak of. The United States needed the markets of Great Britain, needed to have as the freest possible trade with Great Britain, And Britain wanted the raw materials that the United States was willing to provide. So this was, if you want to call it, this was a devil's pact between the infant United States of America and the crown representing the King of England. We will take care of international commerce for you in exchange for relatively free access to your ports and your markets, okay?
Paul, was there a document on this, or was this just by practice? And
Great question, a very good question, and I'm relying on this particular issue on fund rights. And on this particular issue, I've not been able, as you might imagine, there is, in fact, I'll make a short caveat on this. Getting confirmation of a host of these things, which is one reason I'm glad that John Henry Hall has written on it as well, is a real difficult challenge. I almost used a 5-letter word referring to a female dog. Because further along you'll find out that there is an additional amendment to the Constitution that existed for about 40 years and has disappeared from the pages of history, and for which I do have good documentation. So it's hard to find out what has really happened and has disappeared from the pages of history or never happened at all. So I appreciate your question, and it gives me an opportunity to explain why there is a certain ambiguity in some of the things I'm saying.
So is the text of the peace treaty in Paris at the end of the revolution?
1783, yes.
Yeah, is that, the text of that agreement, is it totally available or not?
The text of the agreement should be, but I will guarantee you that the text of the addenda are not. Because all of these treaties have a multitude of addenda, of footnotes, of caveats and exceptions. The treaty is written for the general public, and then you have a bunch of footnotes and addenda for the lawyers.
And when you say sea, are you talking about the Atlantic and the Caribbean waters? Are you talking about all waters?
This includes international waters and navigable waterways. So it will include the Mississippi River, it would include the St. Lawrence Seaway.
But just in North America?
Well, in terms of Britain was yielded the sea jurisdiction as far as the sea jurisdiction impacted United States commerce.
Okay, so primarily the Atlantic.
Primarily at that point, but subsequently it would also involve the Pacific.
Yeah, because the British were in the Pacific. You know, the British were in Hawaii, and
Yeah,
they
and
went around the
subsequently,
world. And
it's worth pointing out that Russia, during the War of Northern Aggression, Russia, the Tsar, sent warships to the San Francisco harbor, and I have not yet documented it, but I think he sent a warship to the New York harbor as well, basically telling the European powers, keep your noses out of this war. As it turns out, however, these changes in jurisdiction, so that the British Crown held one jurisdiction and the American government held the other, has proven more dangerous than the institution of slavery. Somewhere between the Treaty of Paris in 1845, the authority over jurisdiction of the sea fell from the president, the jurisdiction of the sea fell to the President of the United States as Commander-in-Chief, that is, as the leader of the military forces of the United States. That either fell in 1789 with the adoption of the Constitution, or after the War of 1812. But it passed at this point in time from the British Crown to the military commander of the United States. What is, without commenting on the ethics of it, in 1845, Congress extended the jurisdiction of the sea the Admiralty, that's what it's called, the Admiralty jurisdiction, to include lawsuits concerning persons and events occurring on the land. Congress essentially encroached upon the jurisdiction that was governed by common law and said Admiralty law will apply even on the land. Now, the Supreme Court should have challenged that right off the bat. They didn't. Which leads me to suspect that the same forces that caused Congress to enact that illegal change were at work in the officers of the Supreme Court. As people are loath to recognize, the members of the Supreme Court are not apolitical entities. They are living human beings with their biases and corruptions, just as everybody else is. But that was an illegal act that should have been challenged by the Supreme Court, which means that events that should have been governed by common law were henceforth governed by Admiralty law, particularly in American courts. I'm anticipating with this next comment what is part and parcel of the rest of the presentation. Living people have been redefined in American Admiralty law as legal entities. And the first step in that process was the encroachment of Admiralty law onto the land. And as you'll see subsequently, there have been a multitude of ways of reducing living people to legal fictions.
And where do we find that? Because I've read that a lot.
You will almost certainly find it in the writing of commercial law,
Okay.
but, well,
Like the UCC.
we will get to a major expression of that when we're talking about 1933.
Okay.
As you might imagine, authors writing on this subject are castigated and mocked, as are most conspiracy theorists. It's part of history that is difficult to extract. And part of that difficulty in extraction is that the people who want to keep it hidden, the best way to control the opposition is to lead it. So I have no doubt whatsoever that there are a number of agent provocateurs writing in this area of history intentionally to mislead people who are trying to study it. As you have heard but not organized yet, there are three court systems in the United States. Common law, which still exists when you can get it. Administrative law, which is basically statute law. It's the kind of law that is imposed by the president of a corporation telling his underling what he's going to do. That's administrative law. Admiralty or maritime law, which includes martial law, is that form of law that applies to 99.9% of commercial law in the United States. In fact, I am told that there are no courses on common law in the law schools of the United States. They are all dealing with commercial law. Now, and that includes, by the way, criminal law. Criminal law is part, at least much of it, is part of Admiralty law. So that if you kill your neighbor, in terms of the court system, it has a high probability of being the same type of offense as if one seaman kills another seaman at sea, and the captain of that ship has to impose a sentence on the guilty seaman. And if that doesn't sound logical to you, I agree, it's not. It's a total usurpation of the principle of a society that is governed by law rather than governed by the whim of the captain of the ship. And I will make an additional caveat there. What I am describing as the way things are working in our court systems, I believe is accurate, but I will add the caveat. Everybody is doing their very best to give the appearance that it's the way you were taught in school, that we are a government of laws, not of men, and that this law takes precedence over that law. It's obvious that the law applies to Tom Cobb differently than it applies to Bill Clinton. That's not just because Bill Clinton is more wealthy, although that's part of it. It's also because the same principle that applies in Israel applies in the United States. That is, where your class is makes a huge difference as to how the jurisdiction of the sea is applied to you. There are 3 classes of living human beings in Palestine. I don't know how many classes of living human beings there are in the United States. But in Palestine, you're either Palestinian, an Israeli Arab, or a Jewish Israeli. Those are the 3. And the type of law that applies to each of those 3 is profoundly different. And I'm sorry to say the type of law that applies to Americans in this country. It's obvious as an aside, and I'm not, if I'm preaching, I apologize for it. It's perfectly obvious to a common.
There must be a 4th one, and the Palestinians who are living in a place like Gaza.
They're non-persons.
Yeah, but
They're
that's-
totally non-persons.
But that's a 4th category, isn't it?
Well, that's non-human being. But I suppose, I'd have to accept that.
I mean, because
Yeah.
they can shoot them at will,
That's right.
and they can't shoot a Palestinian in Israel at will,
You're probably correct.
okay? Now, they can shoot the one in Israel,
They
But
can shoot
not at will.
they can shoot the Palestinian in the occupied territories a great deal easier than they can shoot the Palestinian in Israel.
yes.
So there are some, I would have to grant your point that there are subtle differences.
There's four, well,
But frankly,
if
in
you can get shot on
Talmudic,
the street, that's not very subtle.
theology, and I'm not saying Jewish theology, I'm
Yeah.
saying in Talmudic theology,
Yeah,
the Gentile soul is closer to that of a beast, and the Jewish soul is closer to that of God. That's in multiple sections of the Talmud.
what's so unreasonable about that?
Well, I just, maybe because my soul is more like an animal, I take some exception to it. Anyway, we're getting away from the American situation.
No, you're right on top of it.
Common law is the law of the land, and what's important about that is that's where people live. The law of the land concerns people, their farms, their barns, their personal property, their personal interactions with their neighbors. That's why it's called the law of the land, and it's why the law of the land is governed by common law.
I mean, they show the right to shoot black men in the street in a place like Chicago. So those 4 conditions are the same here as they are there.
They may be the same, but they do a whole lot more work to cover up the fact that they are the
All right,
same.
well, yeah, we'll agree with that, yeah. But the actual condition is the same.
Joe, let me finish.
I'm trying.
You are trying.
Oh, okay.
Now, the organic law of the land is constituted by what is declared in the Declaration of Independence, the Articles of Confederation, and the Constitutions, and the public law, or what is known as common law. These are the organic law of the United States of America. This land law affects land assets, people, barns, etc., etc., etc. This is a quotation from Anna Wrights, and I like the quotation and I will adopt it for my own, because what she is about is telling people the situation that they have in contradistinction to the situation that they think they have in terms of the government and the management of civilization in the United States. She considered it her mission to teach people to think for themselves. She declares herself to be a Supreme Court of the common law in, at that point in time it was Alaska, but mostly she's talking about Michigan now. But she's not been arrested for impersonating a judge, and she has used the same understanding of the law to not pay income taxes for 20 years. And on this point, on the Mark Twain quotation, she's dead right. It's easier to fool people than it is to convince them that they have been fooled. I'm quoting Anna von Reitz here basically because she is trying to shine a bright light on the actual structure of government in our land rather than the structure of government that we all were taught in grade school was its actual functioning. It's not an endorsement, but to demonstrate that she appears to have some bona fides. There are multiple, and this goes to the question that Catherine asked. There are multiple entities bearing the name Paul Donald Meyer, same name with, starting with caps, Paul D. Meyer with caps, Paul Donald Meyer, all caps, and Paul Meyer. All of these entities almost certainly exist in law. I don't know that for a fact, but anyone can open a trust or a public utility or a different kind of trust, certainly a foreign situs trust, with any of those names as the title of the trust or of the public utility. When I'll finish this one sentence. When Von Reitz started exploring this in the late 70s, she found that one of her cousins had 743 legal entities doing business in her cousin's name. Her father, who had recently deceased, she found out, was paying on 8 different people's mortgages because he had been receiving bills to him in his name for their mortgages. Because the mortgage, the name at the top of the mortgage was his name, so he paid it. Obviously, he was somewhat a victim of dementia because he didn't challenge it. But there are a host of legal entities with these kinds of names. Dawn, you had a comment.
I was going to say that I've heard about corporations insuring the lives of their employees.
Absolutely.
And also, I think I've heard the same thing about citizens of a country being insured by the country.
Now, what is known with certainty, and I'm delighted you raised that issue, what is known with certainty on the basis of individual corporations, corporations are in fact making money by taking out life insurance policies on at least certain employees. And they are the beneficiaries of these policies, so that when the employee either accidentally or otherwise dies, it is the corporation that profits from it. I cannot declare with certainty that that is true of a nation state as well, but it would be amazing to me if the corporation representing a nation state were not also guilty of that, because the corporations are in business to make money. The government of the nation state is in business to manage the resources and responsibilities of that nation state. But the president of the corporation is obliged to serve the welfare of that corporation. So when you're talking about the president of the United States, is he serving the welfare of the nation state of the United States, or is he serving the welfare of the corporation known as the United States of America, Inc.? I leave that as an open question.
May I ask a question?
Please.
So, I've read about this and how you should, for example, now, you say the first one is the best where you're all lowercase.
Correct.
So if you have a capital Paul and D and Meyer, then that's a fiction.
Not necessarily, and this is where we get to 1933.
Okay, so like I know like with birth, when they give birth certificates for babies, they put everything in all caps. And
Correct.
You should not ask for that. You should ask for not. So what is the relationship between, say, a baby gets born and you give them a name and then they give you a birth certificate and it's in all caps. What's the relationship of the baby to the birth certificate with the all caps?
Virtually zero.
It doesn't have any impact on that child at all.
No. Not to the best of my knowledge. It is, in fact, the creation of a state fiction. And the state fiction is a citizen of the state of, etc. So by creation, this is partly interpretive, but that the establishment of that birth certificate basically is the creation of a legal fiction called a citizen of the state of.
And so what's the point of doing that?
Somewhere further along the line, someone can take that legal fiction and send it a bill. And where's that bill going to come to?
But it
It's
does,
gonna come
esta-
to, I see, it's gonna come to you,
That's
whoever
right.
it should.
but it does
Uh-huh.
establish the record that event took place.
Unfortunately, it establishes the record on the Admiralty jurisdiction. Now, if the mother says, I want to register my child's birth on the land registry, that's a whole different ballgame. And I want to get to that when we talk about 1933. Excellent questions. Delighted. But all of these legal fictions can have bills sent to them. And that bill, especially if the person filling out the bill mails it to me, and I'm of sound mind, let's suppose, and this is not merely a supposition, let's suppose a secondary creditor wants to be paid for services that were rendered to the county of Johnson County. They want to be paid, and Johnson County is bankrupt. They cannot pay this bill, okay? It is within the legal right of the secondary creditor to send proportionate bills to every single citizen of Johnson County.
So, let me ask you a question. So if you have a baby and you accept a birth certificate for that baby in all caps, later that baby's an adult, they never objected to it. So under common law, you'd say, no objection makes that
A
valid.
fact in law.
So if they then got the bill from the county, could the county come back and say, well, you already accepted that under common law?
I don't know.
Okay.
I do know how to avoid that issue, but whether the principle that failure to challenge constitutes a fact in law, I don't know the answer to that question.
Okay.
But going back for just a second, Joe's comment that that the birth certificate establishes that a citizen was born, and he's absolutely correct. Unfortunately, it establishes that a citizen was born in the jurisdiction of the admiral, not the jurisdiction of the land. Partly because of what the Congress did in 1845. It brought the jurisdiction of the sea onto the land. It brought commerce into the land, not merely trade.
And
What-
all caps is admirable. Admiralty law.
All caps is admiralty, yeah. But as an addition, not as a contradiction to that, but as an addition to that, in 1933, Franklin Delano Roosevelt did something equally illegal. when you receive a bill, we've already gone over this partly, if it's printed in anything other than all lowercase letters, by definition, that's a legal fiction. And the issuer of that bill is presuming that you, the living man or woman, is going to accept responsibility for it. But the bill is sent to a legal fiction. So when you accept responsibility for it, at least, Catherine, at that point, the failure to challenge a presumption becomes a fact in law. At least at that point, the failure to challenge it becomes a fact in law. The beginning of the fraud, much more follows. The legal fiction entities are associated with several other legal fictions, such as, and this is clearer to me now than when I made this slide presentation. The United States of America, or the United States of America Incorporated, or the municipal franchise, the United States. Multiple iterations of that same name, or intentionally nearly identical names, are all seeking to make the legal fiction, all in capital letters, responsible for bills that a secondary creditor sends out. And they are going to be sending it to Catherine Hogue, or to Paul Meyer, or to James whatever, or to Don Jones. And unless you're smart enough to say, what in the world is this? You're going to pay it. Especially, and I'm anticipating a little bit here, especially if that bill comes from, say, the clerk of Johnson County. Especially if your property taxes go up not by a rational 3%, but go up by an irrational 20%, or an irrational 50% over 5 years. Because those secondary creditors can send out bills to you, and to avoid you catching on to the fact that it is no longer Johnson County that is billing you, but a secondary creditor, they can space it out. There's nothing to prevent them from doing it. In fact, they work so closely with the treasurer of Johnson County, I suspect you would have no way of knowing that from the bill that you got. As I say, all, or at least most of this deception started with moving the jurisdiction of the land onto the jurisdiction of the sea onto the land. We need to define two different words: personage and what's the second word? Personage and barratry. Why don't I have barratry up there? It shows how tired I was. Personage is what that secondary creditor does when he sends you a bill that is listing a legal fiction. That he is treating a living person as a legal fiction in order to defraud him. That's called personage.
Can you give an example of a bill that the county would send from a secondary creditor?
I can't, because to the best of my knowledge, I have never experienced it. I can tell you, however, that, and I may have a clip from a 4-hour presentation that 2 speakers gave. There are 3 states in which secondary creditors attempted to bill in this fashion the citizens of those states by kiting their bills. And I assume it was property tax bills, but it may have been public utility bills. You can do that too, because in 1933, your name you became liable for 3 different legal fictions. Franklin Delano Roosevelt illegally made you liable for 3 different fictions. And those fictions are legally allowed to bill you. Now, the speaker that I'm referring to, and I think I've got a clip further along in here, James. The state or the county, and I'm not sure which, went bankrupt, and the secondary creditor sent out massively inflated bills. And I don't know if they were utility bills or whether they were property tax bills. But Von Dreitz and the people who are working with her were told about this. They had to take the billing to state court. They successfully fought it. And if we have time and if I can make the system work, I'll show you that segment of the clip. But I can't personally because I've never been victimized by it. But Anna mentions one situation that is comparable. Is it clear to everyone in the room that the Federal Emergency Management Corporation thinks they have the right to transplant you if they think it's in the country's best interest? Does everyone agree with that assertion? Or are you going to wait to have the sheriff pound on your door and say, we're moving you? Because there's enough ammunition stored away in multiple federal agencies, not merely law enforcement agencies, but agencies like FEMA, that is intended to control public unrest. I know, I apologize, I'm beginning to sound like a conspiracy theorist. The point that I am making is that, well, let's see what comes up from some of these clips, James. Very, very valid point. I respect the point. Barracktree, by the way.
One example of what you're talking about is that if you're driving your car and you don't have your seatbelt on, they can stop you and give you a ticket for not wearing your seatbelt. And if you push it, they can put you in jail. And what business is it of the state, whether you're wearing a seatbelt or not?
That's an excellent example of the prevalence of admiralty law over common law. That could never be exercised under common law because of the nature of admiralty law and the abuse of admiralty law. The state can assume certain powers over its citizenry, whereas the state, as defined in the Constitution of 1789, did not have the authority. And that gets to another point too that we'll pick up later on. Joe comes to the same point. Living people have been deceived into surrendering rights vis-a-vis. Your example is very simplistic, the seatbelt, but the rights go to all sorts of other factors where rights are guaranteed to people. They are not guaranteed to legal fictions. But if the officer can give you a ticket in the name of Joseph Ossie, and that ticket is made out to a legal fiction, Joe Ossie, the living person, is going to assume that the ticket is his. And going back to Catherine's observation, a presumption that goes unchallenged becomes a fact in law. I got ahead of myself for a moment, but I'm going to drop back. Remember I said that there was a missing amendment? The 13th Amendment was ratified by Virginia in 18 or 19. I apologize for my ambiguity there. But it was the last state that needed to ratify it in order for it to become an amendment to the Constitution. That amendment declared that anyone accepting an office or a title from a foreign nation state was ineligible for public office, and I think they lost their citizenship. At the very least, I know they were at risk of losing United States citizenship. The background to that law was that somewhere between 1789 and 1819, Great Britain set its privateers, its pirates, free to capitalize on and to plague American shipping. In other words, the nation state that at one point in time was entrusted to provide safety for American shipping was turned around and was allowed to act as pirates in a form of piracy on American shipping. Almost certainly that took place after the Admiralty jurisdiction passed to the President, obviously. So somewhere in that period, around the turn of the century, Great Britain allowed their ship captains to behave as pirates on American shipping. And in doing so, they presented their ship captains with a specific title. I don't recall what the specific title was. But the source of the amendment that I'm talking about was in order to punish anyone who accepted the kind of title that the Crown was offering to these pirates. So anyone accepting any title, including member of the bar, by the way, but accepting any title, became ineligible to hold public office and became at least subject to removal of his American citizenship. That's the background of the amendment, and the amendment basically said, if you accept a foreign title, we don't want you, okay? What's important about that is that amendment disappeared between 1819 and 1862. When I say disappeared, it has been erased from history books subsequently, but books published up to 1862 reference the 13th Amendment and quote the 13th Amendment as I have just described it to you. After 1868, the 13th Amendment becomes the amendment to abolish slavery. That's the missing constitutional amendment, and it has been successfully erased, except from those books that quote it. And books that were published between 1819 and 1862, I don't know if I have a picture, but I downloaded several of these pages from books that were quoting it, and it's there. And it has disappeared from the pages of American history. Is it clear why the amendment was passed?
Sure, because the United States was at war with England and vice versa until finally the Civil War took place. And at that point in time,
And Abraham Lincoln was a member of the Illinois Bar Association. And in terms of the legalities of that 13th Amendment, he was not eligible to occupy the office of President of the United States. But he was eligible to occupy the office of President of the United States Incorporated.
how do you deduce that?
Among other things, because he was allowed to be sworn in.
Meaning what, though?
He became president of some institution, some entity known as the United States of America. But the only agency that he could legally acquire that title to would be the United States of America Incorporated. So let's put it this way, if he acquired that title of the United States of America as the government, as the head of the United States government, It was non-binding. It was not a fact in law. Something that's illegal cannot be a legal reality.
And what about his life before 1862 made him ineligible?
I'm sorry?
What about his life before 1862 made him ineligible to be president
He was a member of the Illinois Bar.
And the bar,
Is a title granted by the British monarch.
oh, okay, yeah.
And I think I've read that members of the bar currently are still
That's true.
registered in England.
And they still are, and every time they enter an American courtroom, they have to sign a certificate indicating that they are representing somebody else.
And Lincoln was the first member of the bar that ever served as president.
I don't know that for a fact, but I strongly suspect that, James.
Okay, so what you're saying is our linkage to Great Britain is far more engrossing than we recognize.
The tentacles are like a spider's web, yes. In fact, I will get very soon to the fact that in 1868, a new legal fiction, a new creation, was registered in the state of Delaware, entitled the United States of America Incorporated, and the owners of that new corporation are foreign banks and the Crown, I believe the Crown of England, but I know for certain foreigners, especially Brits, wealthy Brits. Where did all these legal entities and fictions come from? Initially from corporations that were providing services for the United States of America, the one established in 1774 and subsequently 1789, and the territories of the United States. You didn't know that the United States had this many iterations, did you? Now the situation is a little clearer to me now than it was when I made this out, because the company, the United States of America, came into existence in 1789. The corporation, the United States of America Incorporated, came into existence in 1868. And in 1868, it was the British-dominated corporation of the United States of America Incorporated that set up many of these other agencies. Abraham Lincoln, when he was sworn in, but the only agency of which he was capable of serving as the president, he was ineligible to be the president of the United States Major, that is, the government. And if you're confused by this, I sympathize with you, because to a significant extent, it is perfectly less than clear. But the short message is that he was not eligible to be the president of the organic United States of America. But he was eligible to be president of the United States of America Incorporated.
Now, do you think Lincoln knew this?
Pardon me?
Did Lincoln know this?
Yeah.
And that wasn't a campaign issue?
Good question. I am certain that the powers that be, probably in all of the 1850s, knew that a clash was coming between the British influence in the United States and the pressure for state sovereignty coming primarily from the South. Because the very character of the United States as a nation state changed. That change is represented in one sense by the fact that we no longer have a federal United States of America. Before the Civil War, and I'm going to express this as carefully and as clearly as I possibly can, before the Civil War, we had a federal state wherein the federal government was a supranational government of sovereign states. And the sovereign states had delegated very specific powers to the federal government. And the Supreme Court has said that the United States does not have a nation-state government. It has a federal government, okay? So, in terms of what people complain about the exercise of the law, Joe's example of the state having power over the citizen. Before the Civil War, the state, each individual state was a sovereign state, and it administered common law within its jurisdiction on the land. And the federal government only administered admiralty law on the land and on the small amount of land that it controlled, namely the District of Columbia. It would administer the law, the jurisdiction of the land on that, okay? With the Civil War, the federal government literally went into abeyance. You'll hear, Catherine, you probably have read about this. The federal law, or the federal government, is on hold. We now have territorial government and municipal government. The government of the United States is a territorial government that exercises jurisdiction over 57 different territories. No state of the Union has been added to the United States federal system since 1860. Every state subsequent to that, when you read the law and the statements very carefully, every state subsequent to that, Oregon, Washington, Utah, Nevada, they are states in waiting. They're treated in every other respect like a state of the Union that was established in 1789. They aren't. They are all governed under admiralty law administered by, I'll call it the central government. Now, the states were under, yeah, that's the right way of saying it. The states were operating under national government, that is, the federal government was taking care of international businesses. The individual states were taking care of sovereign business within their national territories under the jurisdiction of the land. Since the Civil War, starting in 1868 or 1871. In 1868, the corporation that is owned by Brits was established in the state of Delaware. It was incorporated into the structure of the United States of America, incorporated in 1871. So that legal entity was given authority to manage the affairs of the United States when the District of Columbia law, whatever it's called, the corporation was incorporated into the law that was written in 1871 that had a whole lot more to do with the District of Columbia than it had to do with the national government. But it is a private corporation dominated by Brits that is currently managing our national affairs. So when you elect Joni Ernst, she may be elected as the senator from the state of Iowa, but she's also operating as a corporate management member of a British corporation. How would the New York Times like to get a hold of that? Anyway, that's a different story. But that's, in terms of legalities, that is true. Now, a question that I wanted to ask you. Before the Civil War, the sovereign states were managing affairs within their own sovereign territories according to the jurisdiction of the land. And the United States federal government was managing international affairs according to the jurisdiction of the sea. After the Civil War, the federal corporation was abandoned and substituted with a corporation administering the territories. And rather than stretch this out, the federal administration of the territories gives the central government substantially more power to manage things inside the sovereign states. The biggest problem the southern states in particular gave the central government was they wanted to manage their own affairs. And the central government wanted to spend money, and they wanted to collect taxes from Georgia and spend money in North Dakota. I'm obviously using those as examples. They wanted to function as a strong central government. And the very nature of the federation of sovereign states made that difficult. Not impossible, but made it difficult. So when the government was reorganized somewhere between 1868 and 1871, the people who were doing that reorganization said, let's put the federal state in mothballs and run all of the states like territories. And the people who were making decisions said, we'll do it that way. And that's the way the bylaws of the United States of America Incorporated of 1868 were written, so that the central government would exercise powers that were not delivered to them by the original Constitution of 1789. If you read the Constitution as it is written in 1789, the words look very, very similar to the one of 1868 compared to 1789. The words are almost identical. In terms of the title, one is the Constitution for the United States of America, with the lowercase u, and the way it is listed in the Constitution of 1868, it's the Constitution of the United States of America. Capital U, and I don't know if the and the of are capitalized or not. But the words are almost identical, but the legal substance is substantially different. This goes back to the nature of the destruction of the state with the Civil War. The state as it existed under Lincoln never signed a service contract with the corporation that Lincoln established when he took office. Lincoln established one in 1861. It was supplanted. It went bankrupt and was supplanted in 1868. A little understood, in 1862, legislation was passed that redefined a person to be a corporation, a partnership, a firm, or an association. Now, it did not negate the common understanding of person. In 1862, it said a person could also be a corporation. In other words, a real person could also be a legal fiction. Shortly thereafter, Lincoln declared bankrupt the original United States, but business continued as usual as the United States minor, that is the United States that was subsequently registered in the state of Delaware. The institution of the United States of America were put on hold. You notice I've got the U in lowercase. The institution and law as it was created in 1789 was literally put on hold until the present. The federal government that we have now is continuing to do business as a corporation. That corporation has gone out of business and has been supplanted by a new corporation, I think, a total of 4 times. The 14th Amendment, the one declaring a new form of citizenship, being a person who is born or naturalized in the United States and subject to its jurisdiction. It basically made black liberated slaves citizens of the United States of America because they either couldn't or didn't want to force the southern states to accept the freed slaves into state citizenship. What type of citizenship the black became is open to all sorts of questions, and it would be worth another session just to describe what citizenship means to an African American, to a government employee, or to myself, who was born as a citizen of the state of Illinois. The 1868, the British-dominated, foreign-owned private corporation was incorporated in Delaware, and it declared in 1871, the Congress declared itself the successor of all previous U.S. corporations and incorporated into itself the private corporation in Delaware of 1868. Subsequent statutes made the federal government, in fact, a private foreign corporation that is called the United States. In subsequent statutes, the term United States means only the District of Columbia, not the various states. The District of Columbia is one thing that you can mean when you use the phrase United States. You can be talking about the geographical collection of 50 states called the United States of America, or you can be talking about any of 2 different kinds of corporations. Only living persons on the land jurisdiction have the unalienable rights that we thought were guaranteed us. So when you have the Supreme Court arguing about the First Amendment right to free speech, or the Second Amendment right to the keep and bear arms, they're basically catering to our presumption that we still have those rights. As citizens of the corporate United States, we don't. Those United States, however, have 390 legal fictions in their possession. One of them bears your name. I want to point out that the Federal Reserve banking system existed probably a year to 2 years before it was established as the banking system for the United States. And when it was established by the powerful bankers of the United States and of Europe, including a good number of Rothschild Jews and a substantial number of very wealthy Gentiles. They have been in control of our government ever since 1911, and I was tempted to include a lot of political quotations here, but the very fact that our banking system is controlled by bankers whose interest in profit is substantially greater than their interest in the United States, I think speaks for itself. All of the legal fictions are owned by the corporation of the United States, including the legal fiction that is incorporated on your birth certificate. And it also includes the federal citizens that were, for example, created when the 14th Amendment was passed. By the way, when you volunteered to become a federal citizen, even though you didn't have to be. You volunteered to become a federal citizen when you signed up for Social Security, when you signed up to have withholding held from your first paycheck, or for that matter, when you registered to vote. There are probably 1,600 different ways that the federal government gets you to volunteer to become a federal citizen when as a citizen of a sovereign state you don't need to do so. Your labor and property, and this is something that goes back to this First World War, but was exploited extravagantly in the 30s as a volunteer, as an effort for the war effort. Your labor and property as a federal citizen were conscripted. They were drafted. They became part of the federal property as part of the war effort in World War I. That was never rescinded. So your person and your property technically are conscripts of the federal government. In 1933, Franklin Delano Roosevelt signed over your rights as in terms of your labor and your property in exchange for the Federal Reserve System writing down the federal debt to zero. Between 1913 and 1933, all debts that the federal government was liable to be paid needed to be paid in gold. And the federal government racked up enough bills to the Federal Reserve System that they literally spent more gold than probably was in existence in 1933.
Well, a lot happened between that period of time in American history. How, if you had to rely on the states to raise the revenue to then fund the federal government.
That's right.
That's which was done under the Articles of Confederation. They'd request the states to raise the money, and then
On a proportionate basis.
yeah. So, I mean, then you can debate whether or not we should have entered World War I or not. You can debate that. But the fact that we did required revenue. Required
right.
a great deal of organization that I don't know if you could have relied on the number of states.
In fact, it appears, and I don't have confirmatory evidence of this, but between 1913 and 1933, it appears as if the federal government spent a lot of money, whether it was on the war effort or on off-the-book projects. But it appears as if they indebted themselves to a private banking system. Remember, the Federal Reserve is a private banking corporation. What we are told about it is one thing, but it operates as a private bank. And that private bank held chits, IOUs, from the federal government, far exceeding the federal government's ability to pay in 1933. Joe?
Before 1900 or 1910, the federal government collected a lot of money from whiskey. They collected a lot of taxes on alcohol. Then in 1918, they put prohibition in, and the cash flow from alcohol
Went way down. Very good point. And I've thought extensively, why did the Great Depression of 1930 or 1929 come into being? Well, a good part of it was from the lack of revenue from alcohol. And the cost of the gangsters trying to deal with Al Capone and company in all these major cities. So the cash flow during that time went into the hands of gangsters, not into the federal government. I mean, there's, as you said, let's see, how'd you say this? Things that your teacher never told you? Yeah.
This is one of these mysteries that don't get explained to the public.
And we are all taught that economics and political science are dull and boring.
Yeah,
So no one studies them.
yeah.
Michael Hudson got a PhD in economics, not because he wanted to understand economics, but because he needed a union card. Then, in order to understand economics, he got a job on Wall Street, and then he started understanding economics.
Yeah, so there's all kinds of activities around what you're talking about that took place, particularly when Woodward Wilson bought into the idea of the Federal Reserve or promoted it.
He or was seduced into it.
Seduced, okay, that's probably a better word.
But there's I mean, it was also, didn't it also come into existence in a way to manage the money supply? To inflate the currency when there was depressions, recessions, to restrict it when there were periods of inflation. It was a way to manage what had, you know, all the depressions and problems we had during the 19th century.
You mean the Federal Reserve System?
Yeah.
I think, at this point, I think we have to distinguish between what Wilson thought he was accomplishing, what Paul Warburg was intending to accomplish, and what the American people thought they were accomplishing. Now, I'm very confident that Paul Warburg at Jekyll Island thought he was establishing banking control of the economy of the United States. And they never expected, even the people who were organizing the legislation for the Fed, never imagined that the federal government would be stupid enough to grant them the power to create money. But they did. That was not initially part of the Federal Reserve System.
Well,
That was a quote, a free gift, unquote.
At this time, at one time, banks could, you know, little municipalities would have their own currencies. And so you'd have a lot of wide-ranging values of money that went around the country. At this point in 1900, how was that? Did we have a common currency at that time?
No.
So still.
We had multiple currencies, primarily from multiple state banks.
Well, is that not a problem?
That's where we come to what the United States people thought they were dealing with in the Federal Reserve Act. What Paul Warburg and company wanted was control of the banking system in the United States, and if he gained control of the economy of the United States, all the better. But he definitely wanted control of the banking system. What Congress wanted was a stabilization of the banking system so you didn't have boom and bust cycles and competition between the Bank of New York and the Bank of Connecticut and the Bank of Georgia. What the people wanted was a stable, reliable currency that was going to mean $1 today and not $10 a year from now, $1.50 a year from now. They wanted a certain form of stabilization, and the Federal Reserve System was sold to the American system on that basis. The very people who stood to benefit from the Federal Reserve System publicly opposed it. Because if J.P. Morgan was against it, I'm for it. And J.P. Morgan came out publicly saying, this system is just bad for bankers. You got that all over the American press. And if J.P. Morgan is against it, it must be good.
The
And it was passed.
the other issue is mobility. Before 1920, you know, the average person didn't get out of town, didn't get out of the state.
Excellent point.
So between the railroads and the automobiles, mobility became a major issue where, so.
And mobility, when you have competing banks issuing their own individual banking currency, I may have a $500 of Bank of Connecticut bills in my pocket, and yet if I move and or take a vacation in New York, guess what? I don't have any money in my pocket. Any of you watch Murdoch Mysteries?
Yeah.
Okay. A recent episode of Murdoch Mysteries, Murdoch and his wife go to New York, They have Canadian money. No good. So Joe's point is good.
Yeah. And wouldn't it play havoc with international trade? I mean,
What? What would,
Not having all these currencies.
Yeah, and most, I'll put it this way, most busts are known to be coming and or generated by people who own the banks and are in a position to benefit. J.P. Morgan quite intentionally created the bust of 1907 and made his reputation and made a lot of money on the bust of 1907. And the banks that knew what was going to happen made a lot of money between 1929 and 1933. Paul Warburg's work of controlling the banking system worked beautifully for the banks.
There's another issue that comes up that is monumental. That is the economy of sparsity and the economy of abundance. Every time there was a major bust, and make it very simple, when corn cost you 30 cents a bushel to produce it, and you had to sell it for a dime because there was too much of it. So every time there was a major bust in the economy, it was because of abundance. There was too much of this stuff. I mean, even in 2008, in the housing crisis, they produced too many mortgages that had no backing to it. That produced the...
And the banks knew that, by the way.
yeah,
They
sure
knew
the
that they
banks
were
knew it,
selling
yeah.
junk.
Yeah. So, dealing with abundance compared to sparsity is a major issue that really never gets discussed to any extent.
All very important issues, all concerning the science, which is it's a science of human behavior, the science of economics. It is impossible to study economics from a historical point of view in the United States today, unless you go to the University of Kansas at University of Missouri. Yeah, University of Missouri at Kansas City.
Paul, I've never tried it, but I think it'd be interesting, now that we think about this, to go to the bank and, like if I have a bank account, and try to transfer it to a different bank account where my name isn't in all caps.
Be interesting. to see
I
if-
wonder, because with the banks now, you know, with this buy-in thing, you know, if the bank goes bust, anybody who's got,
Technically, the
Well,
money you
under
just put in the
Admiralty
bank
law.
is the bank's money.
correct. So, but I wonder if you'd be protected at all if you went to the bank and transferred it so your name wasn't in all caps.
Don't know. Don't know, that's,
That, I mean, I just thought.
Yeah.
Yeah.
okay. Roosevelt pledged you have a trade name. If you were a carpenter, you have a trade name by which you do business with the person who is buying your goods. That trade name is defined differently in each and every state of the Union, okay? I believe, and I tried to check this, but I'm not sure I'm absolutely correct. I believe my trade name in the state in which I was born, Illinois, is capital P, Paul, capital M, Meyer. But it's different in every state. It would be capital James D, etc., in whatever state you were born. But each state declares what your trade name is, and that is the name by which you legally do engage in trade, okay? It is an element of the admiralty, of the jurisdiction of the sea, that your trade name is a foreign situs trust. Now, I don't know who created that foreign situs trust. I seriously suspect the banking industry in the state of Illinois for me, and the state of Colorado for somebody else. I strongly suspect the banking industry when you were born, created the foreign situs trust in that state in the name of Janet, forget your last name at the moment.
Forrest.
You know, I'm 80 years old, what the hell. But somebody has established in each and every state a foreign situs trust for each and every citizen. In 1933, Franklin Delano Roosevelt said that that foreign situs trust now belongs to the Federal Reserve System. It's what Louis T. McFadden called an illegal conversion. Conversion of a foreign situs trust to a trust in the possession of a foreign agency. I don't pretend to understand how he did it, but Louis McFadden himself said it was an illegal conversion. But by the stroke of a pen, he changed the ownership of that foreign situs trust, probably from the state of Illinois, in my case, to the ownership of the Federal Reserve System. That's a probably, I don't know that person, because I strongly suspect since the trade name is registered in each and every individual state, I suspect that the state is initially the owner of that foreign situs trust. But the owner became the Federal Reserve System in 1933. So everything you have, all your labor, is billable by the Federal Reserve System. Welcome to slavery, folks.
Call it indentured servitude.
Pardon me?
Call it indentured servitude. In slavery, there was no currency.
Valid point, valid point. Between, okay, I think I've already said this. The federal government owed its debts to the Federal Reserve System in gold. When it wasn't in a position to produce the gold, it presented indentured servants instead. I think I've already summarized that, but I'll give you a few seconds to read it. Holy cow, I saw that at 2 o'clock, didn't I? You have interrupted me a lot, Joe.
Gee whiz, I apologize.
No sweat. I'm teasing you. We've not lived under a federal system since 1860 or 61. We are living on territorial United States of America, and as I think I suggested, the territorial government is easier for the people at the top to manage the states than is a federal system. On the other hand, we have been under unexpressed, not undeclared, but unexpressed martial law since 1917, and it has been reasserted under the National Defense Authorization Act. So, when Boston was locked down for 3 days, A, it was legal, and B, it was an experiment to see how the American public would deal with martial law.
And we just caved in, didn't we?
Yes. They say
Okay,
people in Boston thanked the officers for coming and making them safe, even though they wouldn't let them out of their homes.
In all candor, she is telling you what I've already, in fact, also told you, but I wanted to you to hear it from her.
But the other thing that took place in '33 was the government that evolved was far more socially, I mean, we got Social Security out of it, we got a lot of economic support systems out of it.
You're correct in pointing that out, Joe, and I would submit that these are two actually conflicting activities and goals, because the goal of the one is to save capitalism. The whole purpose of Social Security and unemployment insurance was to give the common man, the 99 percenters, enough so that they were not going to overthrow the federal government. And it succeeded at that. And the capitalists and the plutocrats have incrementally been destroying the New Deal since 1945. And they've actually, with the destruction of the Glass-Steagall Act, they finished the job under Bill Clinton. I cannot say whether Roosevelt intended to create indentured servants or whether he simply intended to get the United States out of bankruptcy. But the effect of giving the foreign situs trusts to the Federal Reserve System indentured you and me to a foreign entity, and without our consent.
You know, the Wayne Jett book, though, when he was talking about Roosevelt, he was saying
I don't have my
about-
hearing aids in today. And Janet,
Yeah.
just shout a little bit at
Yeah.
me.
The Wayne Jett book about Roosevelt, he was talking about that there were, and whoever his economic advisor and all, that there were things that he could have done to end the Depression. There was, they could have, there was enough economic wherewithal to get things going and all, but it was in his interest, and it was in certain people's interest to keep it going. And so even the projects, the work projects, were enough to just keep people surviving, not to get people going on to another level, not really using whatever capitalism had to offer. It was to keep that whole situation going. And I think a lot of what we think we got out of the New Deal, if you look at the economics that was going on, if you used capitalism and would have got the whole economy going, that would have been preferable than just giving people some little benefits here and there.
But
So-
heavens, Janet, you're talking about socialism. You're talking about communism. You're talking about the destruction of my ability to become a multi-billionaire. How dare you do that?
I think that there's this use of these obsolete words, like capitalism, socialism, or communism. There needs to be a totally new vocabulary established in order to move forward. And here's a very, okay, if you go to the Hoover Dam, how much benefit came out of the Hoover Dam and what they paid for it? You know, when you look at the amount of electricity that was generated out of the Hoover Dam and what they paid for it through these programs you're talking about earlier. So the capitalization of things that were implemented during the Depression should have been restructured. And a simple example in today's world, West Virginia, if West Virginia was connected by 300-mile-an-hour trains to Washington, D.C., you'd be a half an hour from D.C. to a huge...
And you'd have a land boom, you'd have a land property boom in West Virginia, and the smart thing to do there would be to lay a tax on the increased property value of West Virginia property in order to pay for your high-speed rail.
And you would employ all of those old coal miners,
Absolutely.
and you could
Absolutely.
repopulate the country, you could put in new trees, you could reforest the place, and you could build an economy that would work for...
That would work for everybody, but I was being facetious when I responded to Janet, but I was also being very serious. Capitalism is a system that needs poverty. It absolutely, just as Zionism requires anti-Semitism, capitalism requires poverty, because it is in the structural distinction between the rich and the poor that capitalism is most attractive.
Okay, but it also could be modified to perform, providing a good substance for everybody involved. It only depends on how it's structured.
Right.
You know, is it,
I mean, and then when he was talking about, just, FDR was trying to destroy the middle class. Well, the middle class can be capitalist. I mean, they can have capital that they're investing in businesses and everything. So to make it the poor against the rich, I mean, he was saying how they could have made capitalism work. But Roosevelt didn't want
No,
that to succeed.
they
And
did.
so,
I guess why would he not want that to succeed?
because he was really working for the banks.
The top
The
0.1%.
Right, and they were dumping milk, he was forcing everyone to sell their gold to the federal government, and he could have used that gold to help the poverty that was going on, but he didn't.
Well, I guess it's gonna be hard to convince me that Roosevelt did not respond to the Great Depression by action.
okay, but
No, no,
Wait,
no,
Judge
that's,
Wilkins, this
partly because of time, I'm going to semi-summarize that. The question is not whether Roosevelt responded to the Great Depression. The question is, to what extent was Roosevelt doing what he had to do in order to preserve capitalism, or was he doing, let me put it this way. Roosevelt, Franklin Delano Roosevelt, was a capitalist par excellence. He was a member of the ruling elite. And he told, this is recorded fact. He told his fellow ruling elites, either you let me give the poor some of your wealth, or they will come and take it all. You're going to let me redistribute wealth some, or you're going to let the poor, by revolutionary means, redistribute it according to their desires. And the record shows that they said, we'll give you this much leeway, and Roosevelt took this much leeway and gave the poor, not even the middle class, gave the poor enough so that they could live, enough so that they would have some hope for the future. And it's testament that it was not, that even then, as modest as it was, and I agree with Janet that what he did was very modest. As modest as it was, the people who are making decisions have been undoing that since 1945 to
And
1998.
he raised the tax on the middle class, quite a bit. So it was, again, he was going after a certain group of people, and,
Well, it's not like he wasn't working with a cooperative Congress either, and this is legislation. that has
Or
to pass.
cooperative Supreme Court.
Or, yeah, exactly, because a lot of what he was pushing for. Now, I know I'll accept that he was modest, but I'm not gonna accept he was doing this for a certain privileged class, even though he was a
for
part of it.
mercantilist, well, Wayne Jett says, it depends on,
Yeah.
but you know, you had this group of people like Henry Wallace. Henry Wallace was a major factor in solving the Depression, in getting the farm economy working, getting the country working. And that part of the discussion never shows up, because in 1944, when they shoved Henry Wallace out of the presidency, vice presidency, and put Truman in, all of that disappeared, right after the war. The war, that's where the war machine really took over the country.
I mean, Roosevelt was, there were people on the left certainly trying to be more radical than he was. He was a moderate in that way. I mean, we had Huey Long, we had Francis Townsend, we had, Charles Coughlin and his cadre. We had a lot of people who were pulling, and I think there was some concern that the country was fragmenting. So in that sense, the whole Social Security Act was kind of a modest thing to do, but And also, there just wasn't that much money to invest. Where was he going to invest the money into public works? He did, he did something, of course, but.
Well, I'm not sure, what point are you making, James? That he
Well,
was- that he
I
was-
guess I was reacting to I don't quite understand the view of Roosevelt that I heard, that's all.
See, I think there's another major problem that we don't think about, that is the sparsity, we as the population, in relationship to the size of this country. If you compare us to Europe, the density of population, Germany, France, etc., is so dense compared to we, except in Chicago or New York, or where the hell.
Yeah, except in half a dozen major centers, right.
Okay.
Okay, your point is well taken there.
So, I mean, this business of economics is a lot more complicated.
Well, I think since this is a class about what your teacher never told you, one of a number of issues that we're raising is what is another or several other perspectives on the history of economics frankly, of the whole 20th century. Because there are multiple ways of seeing Franklin Delano Roosevelt. He is seen in the public press as the savior of the middle class. Well, I have news. There are several other ways of looking at FDR, as there are several different ways of looking at Woodrow Wilson.